Thank you, Mr. Chairman. I very much appreciate the courtesy, and I apologize to my colleagues for jumping to the head of the line. Ms. Reynolds, I just want to make sure I've got this right for the record. Is it your testimony that Chairman Rowe and I and others who have expressed concerns about the NLRB acting right now and when their constitutionality is challenged are, quote, serving the narrow interest of the 1%? Is that your testimony?
Well, Mr. Kline.
Sort of yes or no.
Yes, Mr. Kline, that is serving those interests.
Thank you. Reclaiming my time. That's extraordinary. Mr. King, a couple of quick questions. Could you tell us why it was that President Bush was unable to use recess appointments to fill vacancies at the NLRB between 2008 and 2011?
Yes, Chairman Kline. The Senate was in session. The Senate was gaveling in and gaveling out every 3 days at a minimum and conducting business. The Senate was available for business. So constitutionally, the President was prohibited from making recess appointments during those time periods.
So that would be similar to the circumstance we've just been in, where President Obama decided to make these recess appointments. Is that correct?
Yes, sir. You're exactly correct.
Okay, so the claim that we've heard a number of times that these recess appointments have been made by multiple presidents year after year don't account for the fact that the Senate was in pro forma session. Is that correct? The intra-recess appointments?
That's correct. Those are all red herrings. Those are diversions from the constitutional principles that we should be talking about here. Total red herrings. What President Clinton, President Carter, First President Bush, others have done, that doesn't have any bearing at all on the facts of this case, and I wish people would pick that up.
Thank you. I think we just did.
Right.
I want to get this right, so I've got a note here to make sure that I've got the numbers right. But according to my notes here, over 27 months, again, Mr. King, starting in 2008, the NLRB issued approximately 600 rulings in unfair labor practice and representation cases with 2 members. On June 18, 2010, in New Process Steel LP versus NLRB, the U.S. Supreme Court held that the NLRB must maintain a membership of at least 3 members to constitute a quorum, at the heart of this whole discussion. What happened to the rulings the 2 members issued?
Chairman Kline, they all had to come back and be reconsidered. But an important point that you raise is that then Chairman Liedman of the NLRB, a Democrat, and the other member, the second member, Member Schomburg, Peter Schomburg, they agreed to not decide controversial cases. They agreed not to overturn precedent. They showed great restraint. The cases they did issue, they issued unanimously. So when those cases came back, they were fairly easily processed, albeit there was that delay. Contrast that, Mr. Chairman, with what we have today. We have an NLRB going full speed ahead, according to the Chairman, with 2 recess appointees that are now highly questionable from a constitutional perspective. We have expedited election rulemaking going forward. We have no restraint at all. So what this board has done is totally opposite of what a Democrat and Republican board member scenario did prior to New Process deal. It's very unfortunate, bad public policy.
So these rulings are actually much more controversial, is your point, I believe, than those that were made who got overturned in the past. And so whether you're 1% or 5% or 10%, if you're in business out there and you're now trying to decide about the constitutionality, the legality, the effectiveness of the rulings of the NLRB, you've got to have some concern. If they were overturned in the past, why wouldn't they be here? So those of us who have called for the NLRB to stop activity until the membership can be constitutionally reestablished are concerned about workers, unions, employers, the economy, because there is great uncertainty out there. And it's very difficult for employers and employees and unions and all those to make a decision with any confidence that that decision based on an NLRB ruling will stand. And that's our concern here. And with all apologies to our witness, it's not just because we're concerned about the special interest of the 1%. Thank you. I yield back.